Resuming debate, Senator McPhedran.
Thank you very much, Your Honour. I also want to acknowledge the level of debate on this very important bill. And I also just want to share with you that I have a colleague in the United States that regularly watches the Senate on CPAC because she finds it to be such a great relief. So I think that we have something to be proud of here in terms of the courtesy with which we conduct ourselves. My amendment addresses the transitional provisions of this bill at Clause 75, which applies the one-year asylum application deadline retroactively to June 2025, which is when Bill C-2, the predecessor bill, was tabled. This amendment is based on procedural fairness and rule of law. This amendment addresses the transitional provisions in Bill C-12 at Clause 75, which currently applies a one-year asylum application deadline retroactively to June 2025, which is when the predecessor bill, C-2, was first introduced to the House of Commons. My amendment adds a few words to Clause 75 to bring it closer to procedural fairness and international obligations. To bring this home, I offer this example of how humans would be affected if Clause 75 is not changed. Think of a family from a conflict zone. They get through the rigorous IRCC review process. They land in Canada in June 2024, when the deadline currently in Clause 75 does not exist. They take the time to find a home, get their kids into school, start language classes, settle into employment and community. About a year later, let's say July 2025, still no Clause 75 deadline in existence, they file for asylum. The retroactive activity in Clause 75 would impose a deadline about which this family could have had no knowledge because it didn't exist. The impact of an unchanged Clause 75 would mean that they would get no notice, creating an obstacle they can't get over because the deadline did not exist. Therefore, they have no chance of making their case in an oral hearing before Canada's renowned and respected Immigration Review Board, a right that asylum seekers in Canada have had for many years. In other words, this family would be caught by the retroactive Clause 75 without ever being given notice of the deadline because at the time they applied, the rule did not exist. Honourable colleagues, this is contrary to how the law works in Canada. We have notice procedures, gazetting of law and regulations, so that individuals and organizations impacted are aware of the laws that apply to them. To do otherwise is to act contrary to the rule of law, contrary to Canadian values, and to undermine public trust. When questioned today, this bill's sponsor, Senator Dean, referenced the backlog of 300,000 before the Immigration Review Board as a justification for the parallel pre-removal risk assessment system aggrandized by this bill. And, credit to Senator Dean, he did not try to claim that the IRCC employees who will run the PRA review are better trained or better qualified than members of the Immigration Review Board, because they are not, and they will not be. Common sense would see adequate funding to the IRB to increase its capacity to process cases. The current funding to the IRB is for 60,000 cases, but in fact, the IRB issued 102,000 decisions last year, of which 78,000 were refugee protection cases. The IRB is measurably returning high value for investment, a 42% productivity increase. If adequate funding was increased to the IRB, the backlog would steadily decrease, in compliance with international law and the Canadian Charter of Rights and Freedoms. Spending more money on an inferior parallel system with less qualified decision makers does nothing to address the volume of cases. It just moves the queue. You heard evidence from Senator Simons today that debunked the PRAW as a viable solution. Senators have raised a concern regarding individuals involved in criminal extortion who then apply for asylum. Extortion is a criminal offense, prosecuted under the Criminal Code of Canada, which also applies to asylum seekers. Criminal law system always takes precedence over immigration law, and issues of serious criminality can be raised at any point in the immigration refugee process. The current system makes people with, quote, established links to organized criminal networks, quote, inadmissible. There are clear processes in place for addressing criminality and organized crime through the inadmissibility provisions of the Immigration and Refugee Act. These include powers that the government already has. 2, suspend the consideration of eligibility in order to wait for determination of inadmissibility or to wait for a court hearing on serious criminal charges. Suspend the study of the claim by the Refugee Protection Division of the IRB in order to wait for determination of inadmissibility or to wait for a court hearing on serious criminal charges. Redetermine eligibility of a claim that has already been referred to the RPD. The BC extortion cases are ones already being criminally investigated, so the government already has the tools to proceed, and the retroactivity in Clause 75 does not add any new powers because they are not needed to deal with criminality. Honourable Senators, I hope you will join me in upholding confidence in our criminal justice system to do its job and to uphold procedural fairness and rule of law in Canada by removing the retroactivity in Provision 75 and adopting this amendment, which, like most laws in Canada, activates the deadline as of the date of royal assent of this bill. Through this amendment, a few words replaced in Clause 75 would result in a fair process consistent with the fundamental principles of justice and charter-protected rights: life, liberty, security, and consistent with the title of the Act being amended, the Immigration and Refugee Protection Act. Therefore, I move that Bill C-12 be now not read a third time, but that it be amended in Clause 75 on page 35 by deleting the heading before Clause 75 and replacing lines 1 to 16 with the following. For greater certainty, paragraphs 101, sub 1, sub B.1, and sub B.2, and subsection 101, sub 1.1 of the Immigration and Refugee Protection Act do not apply to a claim for refugee protection made before the day on which this Act receives royal assent. Thank you. Merci. Miigwech.
In amendment, it was moved by the Honourable Senator McPhedran, seconded by the Honourable Senator Arnold, that Bill C-12, as amended, be not now read a third time, but that it be further amended in Clause 75. Suffit, dispense. On debate, Senator Dean.
Thank you very much, Speaker. Thank you, Senator McPhedran, for your amendment and the thought that you've put into it, and for the persuasion with which you've so eloquently described it. Colleagues, as you've probably figured out by now, there's a lot of focus on case management, a lot of focus on making efforts to prevent surges in claims from individuals making claims ahead of the coming into effect date, which could result in yet another surge of claims when thousands of claimants are already not having them heard in a timely manner. So this approach is designed to help maintain a consistent approach to cases in the inventory and to help manage the asylum system effectively. And on that basis, I believe this motion should not be supported, colleagues. Thank you for your attention.